I'm Rob Port from SayAnythingBlog.com, North Dakota's most popular political blog. Here with North Dakota Attorney General Wayne Stenehjem, who spent the last couple of days in Washington, D.C., observing the Obamacare proceedings before the Supreme Court. Attorney General, thanks for your time. I understand it was your first time getting to actually hear a case debated live before the Supreme Court.
It was, and that's why it was a real pleasure. I know that this was the hottest ticket in Washington, and so it was a real pleasure in addition to being there, because North Dakota is a plaintiff state, and so one of the original 14 plaintiffs. So I felt that it was important that I be there. I did happen to get to luck out because in addition to being in the courtroom, which there were so many who wanted to just have a chance to be there, I was in the very front row for each of the arguments over the 3 days that the court heard the cases.
Oh, so you were able to hear most of the case, because from reports it sounded like the attorneys generals were sharing access to the court, but you were able to hear all of the arguments?
That's right. We had a limited number of seats that were assigned to us, but in addition to that, attorneys who are admitted to the U.S. Supreme Court bar have a special line that they can get into and then get to sit in the courtroom in front of what's called the bar of the Supreme Court. So by getting there early, I lucked out, got those seats, and was in the front row center for each day of argument.
How do you think the case went? And we've obviously been inundated with media coverage about what Justice Kennedy said and what Justice Scalia said, and everybody trying to read the tea leaves on what their path of questioning meant in terms of how they would ultimately rule on the case. What was your impression from the arguments?
Well, you're exactly right. It is hard to read the tea leaves. You can never really fully discern what a justice might be thinking and where they might ultimately wind up just based on the questions that they ask. Because sometimes they'll ask questions as devil's advocate, or maybe to get an answer to a question or a concern that they have in their own mind. And so it might sound like they're coming from somewhere else and might actually wind up being helpful or not helpful to the case. But I think that it was eminently clear that the 4 liberal justices on the court are going to vote to uphold the law based on all the questions they were asked, particularly those that were asked of the government. I simply got the impression that they will be the 4 on one side, and we'll have a possibility of 5 on the other side, with largely agreed that Alito, Scalia, and Thomas will vote to overturn the law. That leaves Roberts, who some people think of as a question mark, but he's a reliably conservative jurist, and I fully expect him to vote to at least overturn the individual mandate. And then based on questions, and Justice Kennedy held things pretty close to his vest, but I think very telling was his first question that he asked is this. He said, if the individual is forced to purchase insurance, it changes the relationship of the federal government to the individual in a very fundamental way. And so he certainly gets it, because that is exactly it. We are here in a case that probably is the most significant case in the history of the court that tests what the extent of the power that the Congress or the federal government has. And either they're going to overturn this individual mandate, a requirement under the Commerce Clause that individuals purchase a product for the first time in history, whether they want it or not. And if they do uphold that requirement, the questions by most of the justices who look like they are on our side seem to indicate then what is the limit. And the answer to that question is there is no limit. And that's the reason that we are so very concerned, and why we think that it's critical, even beyond the issue itself, which is health care now, but will be something else in the future when we go in and the Congress decides that they're going to use the Commerce Clause to compel activity by citizens of the U.S. And that, after all, as you well know, was never part of the deal when the Constitution was written, when it was adopted by the original colonies, and when each state decided to become a part of the Union. We were all fully aware that the promise, the deal, the contract we made is that we would have a Constitution that limits the Congress to certain enumerated powers, and beyond that, all other powers belong to the states or to the citizen. It's that fundamental.
Is there an aspect to this case, and like I said, I mean, the media coverage has been wall to wall But as somebody who was there and observed things firsthand, is there an aspect of this case that's maybe getting overlooked in a lot of the coverage?
Well, I don't know if there's an aspect that's getting overlooked. I think that the point that I constantly am reminding people is that you can talk about healthcare, and everybody knows that the healthcare needs some improvements and things have to be done, but they have to be done pursuant to the laws that are enacted the way the Constitution intended that statutes would be enacted in our country, and this law was not done that way.
We've had the oral arguments before the Supreme Court now. What's the next step? I mean, how quickly is there going to be a ruling? I think I heard at one point that under Justice Roberts, Chief Justice Roberts, that the court was actually pretty efficient at producing rulings. But like you said, this is probably the most significant case. I think this is the most significant case to come before the Roberts Court. How long before we can expect a ruling on this?
They will adjourn for the year at the end of June of this year, and so if they're going to complete their docket and issue ruling in all the cases that are before them, they will have to do it before the end of June of this year. So it's widely expected that we will have a ruling one way or another that day. But this case too, remember, was more than just one case. There actually were 4 different issues that were brought before the court, and they kind of vary on their import and so forth. But the first day was kind of an esoteric day when we discussed the Anti-Injunction Act. That's a provision that says an enactment that says you can't bring a challenge in court to a tax issue until you've actually paid the tax. Now, in this case, the tax doesn't, I shouldn't say tax, it's a penalty. They bend over backwards to say it wasn't a tax, to pay a penalty, but nobody has to pay that penalty until the end of 2013, so the beginning of 2014. So that was the first day of argument. Interestingly enough, the government the feds who wanted to have this issue determined came in the first day and said, well, it's not a tax. It's a penalty. And then Justice Alito very astutely commented, well, that's interesting. Today you're in here arguing it's not a tax. Tomorrow you're going to come in and you are going to argue that it is a tax. And that, of course, met with great laughter, but it did indicate the hypocrisy of the entire issue, because you will recall that at the very beginning, as this law was being passed, the president himself, President Obama, said this is absolutely not a tax. But then he authorized his Justice Department to come into court and argue on day 2 that it is, in fact, a tax. I thought that was very interesting, though hypocritical. Then the next day, of course, was the issue about the individual mandate. That's the one that probably most people are well aware of. But the third day, then, the question yesterday was on severability, and that is the answer to this question. This law goes on for 2,700 pages. But the capstone, the key provision, the linchpin in the entire thing is this individual mandate that provides the penalties, that will provide the money to fund some of the other provisions in the law. And the question is, would Congress have enacted the rest of this provision without the individual mandate? Now, most supporters of the bill said that this was a key part of the entire law, though the Justice Department is arguing just the opposite at this point. So the question is, if the individual mandate is unconstitutional, then should the court permit the remainder of the law to go into effect, or should it say Congress would not have enacted it without the individual mandate? They need to go back to square one and start over. The position of the states was that that's exactly what ought to happen.
And that was the subject of Scalia's sort of humorous comments that we heard so much of, suggesting that it was cruel and unusual punishment to expect the justices to go through and read the entire bill.
That's exactly right. And of course, that was met with great laughter and so forth, because he mentioned the Eighth Amendment prohibition on cruel and unusual punishment. The problem, he was being whimsical, of course. The problem isn't that they would have to go through and read the bill, because that's a relatively simple thing to do, though it's very lengthy. But you can do that. The question that he really was worried about was not reading it, but trying to discern then, after reading it, which of these provisions would the Congress have enacted if the individual mandate had not been a part of the entire package. And that's the position that becomes rather impossible. When we went initially to the district court, the federal district court in Florida, and got our ruling from Judge Vincent, he not only said that the individual mandate was unconstitutional, he also said that he thought that that the Congress would not have enacted this law without it. And so he ruled the whole thing unconstitutional. It got appealed to the 11th Circuit, and the 11th Circuit agreed with him that the individual mandate was an overstretch of federal power, but overturned him on the part that said that the remainder of the bill would fall. So now we've got the Supreme Court. That's the determination they're going to make, but only once they've determined that the individual mandate is unconstitutional.
It would seem hard if you get to the point, and I realize you've got a limited amount of time, so I just make this the last question. It would seem hard if the Supreme Court does rule that the individual mandate's unconstitutional, like Justice Scalia suggests, going back through the bill and trying to figure out what Congress would or would not have do. Why wouldn't they just throw out the entire bill, and if Congress wants to try to reinstitute some provisions of the bill on their own as law rather than the entire bill in total, wouldn't that be a better solution rather than the court guessing what Congress would have done?
That's what the position of the plaintiff states is, because it is, as I mentioned, this is a very lengthy law. There are interrelated, interconnected pieces of this legislation. One part is inextricably linked to other parts of the legislation, and for the court to be able to go through and attempt to make a guess on all of those things is asking for impossibility, because those are questions that belong in the political branch of government, and that's the Congress. That's why we think they should just throw the whole thing out, start over, and look at some of the things that a lot of people agree are worthwhile considerations, things that Congress could do and could do in a constitutional way, but do it without all the vote trading. And the Cornhusker kickback, for example, came up as an example of all the things that were thrown into it, and at one point or another. And so it seems to us the proper thing is start over.
Thank you for your time.
My pleasure. And we will be looking forward, and I hope that we will have a victory. I feel very good about it. Can I make one other point about this?
Absolutely.
Okay. It was 2 years ago that the attorneys general, 14 of us in the United States, across this country, filed our lawsuit. And you will remember that there was some concern at the time because the law was much more popular then than it has turned out to be. But those of us attorneys general who filed this lawsuit were met with derision from a lot of corners, including constitutional law professors from out east and west and elsewhere, who said our lawsuit was frivolous, who said it had no merit, who insisted it was going nowhere. And where we wound up instead was in the United States Supreme Court with an absolutely unprecedented hearing schedule of 6 hours of court argument that stretched over 3 days. And though we think we might win, one thing is for certain: all of those people who said that our actions defending the Constitution of this country were frivolous turned out to be wrong.
I think that's absolutely right. Again, thanks for your time. Appreciate your insight.
Anytime. Thanks, Rob.